It seems to me that you are actually changing the standard. You've accused the district court and the Court of Appeals of doing so, but in our case law, consistently, we've said that the first prong relates to a showing of significant sub-average general intellectual functioning. The words IQ score under 70 does not appear. Though that's not the standard. I appreciate that that's one of the ways in which science has determined that you can make such a showing, but we also have allowed for evidence related to adaptive functioning to be taken into account when looking at intellectual functioning. So I think what you've done is shift this to be all about the IQ test in a way that is not supported by our case law.
Atkins cited the 4th edition of the DSM, and I think the phrase that you just used appears in that edition, and then further defines what general intellectual functioning means. And it used to mean an IQ of 70 or below. Before that, it was 65. Now they're saying it's 75. But IQ has always been the primary criterion by which intellectual...
Primary, but not the sole. And we've never said it's been the sole. And what the district court did here was look not only at the IQ scores holistically, but also other evidence of adaptive functioning. And that's precisely what our case law says that the courts are supposed to do. So let me ask you, why do you think that the test should be simply and solely IQ score cut off at 70?
IQ is originally how intellectual disability was defined as a condition, and it's always been the primary criterion, and states are allowed to take the best evidence of intelligence and to make that the test.
But what do we do with the brief of the American Association of Intellectual and Developmental Disabilities, the actual experts in this area, who say, and I'm looking on page 24 here, other than requiring the careful use of clinical judgment and professional responsibility in performing a complete analysis, there can be no single mandatory empirical method for clinicians to use in considering multiple scores or in determining whether or not someone is intellectually disabled. They look at a lot of things. So reducing this to a single score seems to me misguided.
Well, if there can be no one mandatory method, then it's up for states and their legislatures to decide. That brief also said on page 15 that IQ remains the best single representation of intellectual functioning. And the alternative is very unworkable. Courts do not have a means by which they can compare the evidence at prong 2, for example, that he struggles with navigating the subway system or doesn't know how to cook certain dishes, against the objective IQ evidence. How many points?